European Commission remains an important partner for us, but together with the trends around the reform, now the ball is in the court of DPAs.
Hello and welcome to ViEUws and our leading policy interviews. Joining me today to talk about safe harbour and data protection is the European Data Protection Supervisor, Giovanni Buttarelli. Thank you very much for being here for that big story that everyone is talking about, and that is the European Court of Justice ruling that the safe harbour agreement, the data sharing arrangement between the EU and the US, is invalid. What's this going to mean for local authorities in the various member states, and what's it going to mean for consumers overall?
The first takeaway is that powers of DPA are strengthened a lot, even against the decision on safe harbour, which is now invalid. So the European Commission remains an important partner for us, but together with the trends around the reform, now the ball is in the court of DPAs, and this is why I'm insisting we speak one voice.
And is the trust in the Commission a little bit undermined by this ruling?
Not really. The Commission remains the guardian of the treaty and an important partner for independent DPAs. But now, of course, a careful approach is to be taken for a potential renegotiation of a new agreement with an important partner, strategic partner, as the US is. At the same time, we have to horizontally make an analysis on other existing legal instruments, contractual clauses, binding corporate rules. They are not directly affected by the judgment. They are valid, and a lot of investments have been made. But of course, the judgment is a landmark one. It will count a lot, much more than previous judgment on, for instance, data retention and the so-called right to be forgotten. For the simple reason that there are three sentences. Data protection system should serve the man. Data protection legal framework aims to protect, to ensure a high level of data protection. And the third, which is very important, any transfer to third countries is based on a careful assessment of adequacy, which means existence of not an identical level of safeguard, but essentially equivalent.
Well, you mentioned these other instruments, model clauses, binding corporate rules, things like consent forms. I mean, those give some sort of surety to businesses, but for consumers, if they were to be brought before the ECJ, do you think they would stand up to that same scrutiny in terms of whether security agencies in the US might be able to still look at data that is transferred from the EU? We
started an analysis together with other colleagues to be continued by next week in an exceptional plenary meeting of the Article 29 Working Party. As said, these legal instruments will continue to play an important role. I cannot exclude they could be amended one day. Even the data protection reform speaks about the need in the midterm to pay attention to potential updates. But for the time being, they are not directly affected, though data protection authorities may adopt decisions depending on the legal system in certain countries. So that's the complex legal framework to be analyzed.
Okay, thank you very much.
My pleasure.
That's it for our interview on data protection, but do stay with us on ViEUws.eu, where you can see other interviews and, of course, our Brussels briefing on tech, as well as a full debate on the digital single market strategy.